Welcome back to the afternoon session of the September 19th, 2024 Investor Advisory Committee meeting. Danielle, do we need to note if any IAC members have joined or departed since this morning's roll call?
Nancy Lamond has joined the meeting.
Thank you. Our afternoon agenda begins with our panel on key topics from securities litigation, shareholder proposals, and tracing in Section 11 litigation, which will be moderated by Colleen Honigsberg. Colleen?
So, thank you, Brian, and I want to thank all of the panelists so much for coming here today. So I'm incredibly excited for the presentation, and I'll just go through and introduce each of you guys quickly. So first we have Bobby Bartlett, who is my colleague at Stanford Law School, where he is the W.A. Franke Professor of Law and Business, and he is also the faculty co-director of the Rock Center. And he is a professor by courtesy at in finance at our business school as well. Thereafter, then we have Marie O. Huber. So Marie is previously the legal counsel for both eBay and Agilent Technologies. She currently serves as an independent director, and she has been in the industry serving in a regulatory and legal capacity at Fortune 500 companies for the past 25 years. As a fun fact, while she was in DC, she also attended Korean Thanksgiving at the White House. So. Next, we have Rob Jackson. So Rob is a professor at NYU School of Law. He is also a former SEC commissioner, and most importantly here, my former professor. Next, we have Trevor Fay. So Trevor is the CEO and founder of COPA, which is a real estate blockchain company. He also was previously the chief operating officer of Claridge Properties. And although he is a trustee at Lacera, he will not be speaking in his capacity as a trustee of Lacera. And then finally, we have Bob Stebbins, our third Robert on this panel. So Bob Stebbins is a partner in Wilkie's Corporate and Financial Services Department, and he is co-chair of the firm's corporate governance practice. He previously served as general counsel of the SEC. So thank you all very much. And for the first topic, we're going to discuss Slack and tracing under Section 11. So Bobby's actually going to start us off with a PowerPoint presentation.
Thanks, Colleen, and thanks to members of the committee and allowing me to present. I do have some slides prepared, so those can be posted. And I should also note that I typically use animation when I make my slides, which is ill-suited for today. So maybe I'll just tell you to maybe go through maybe the next 4 taps, and then we'll set it up in that fashion. So I thought I'd start off by just giving an overview of this concept of tracing and why it's become problematic. And so if we think about sort of the paradigmatic public offering, the issue sort of is that anytime you sell securities in this country, the 33 Act says you have to register the transaction unless there's an exemption. And so we think of the different ways in which a company can issue securities. Sort of, the first issuances might be to employees, founders, venture capital investors. That's a sale of securities, but it's exempt, which you see in the sort of the picture here. It's the lowest issuance of securities. But then a company might do a public offering, in which case there is no exemption under the 33 Act. And so then you have to register the securities and file a registration statement that's vetted by the SEC, made public. And then, of course, those initial investors in an initial public offering are going to typically then turn around and immediately sell the stock into a public market. Those securities will actually be DTC eligible. That is, the depository trust company will sort of have them deposited. They'll get a QSIP number, and then they become freely tradable in the secondary market. So if you can just click through a few more slides. Okay, so these. Okay, if you could, yeah, stop there. So we think about the secondary transaction from the initial investors into the stock market. That's another sale of securities, but that's exempt as not involving an issuer, underwriter, or dealer, so no registration is needed there. And then we come to a really important transaction, which is that the prior stockholders, venture capital investors, founders, they don't sell registered shares. Instead, what they do is they resell their securities in an exempt transaction, and it's exempt largely by means of Rule 144. Contractually, it's historically been the case that these investors will lock themselves up. They'll contractually promise not to sell for 180 days so that the market can stabilize. And so then after that 6-month period, historically, they would then sell into the market. Okay, so that's a traditional IPO. Now, there's also another way that you can do an offering, which is through a direct listing. And so if you could click through maybe the next 4 or 5 instances. So how does this differ from an IPO? So the primary way is that you basically segregate the stockholders of a company into 2 buckets. Okay, so there's basically the insiders, the control persons, the founders, VCs, anyone on the board of directors, on the one hand, and then everyone else on the other, non-controlling people. And so it turns out that if control people, founders, VCs, directors, want to sell their securities, that has to be registered, okay, because of the information asymmetry that exists. So registration statement is again filed with the SEC, except you sell directly onto the market. The QSIP is applied for, the DTC, shares are deposited with DTC. And then the other stockholders simultaneously in the other bucket are also going to have their legends lifted for 33 Act restrictions. They're going to have their DTC eligible securities, and they can simultaneously sell on that same day. So if you could click through another couple of clicks. So therein lies sort of a direct listing. Okay, so now one issue that pertains to any public offering is the considerable concern for misstatements and fraud, and that's why we have Section 11 of the 1933 Act, which imposes strict liability for any material misstatements or omissions in the registration statement, and it applies to the company as well as to a list of others, including underwriters, directors, and controlling persons of the issuer. And it's strict liability, which is unusual in the securities laws. And so if you could click through 2 more times, please. So why is it? Why do we have such an onerous system of liability? It's largely because of the concern that there's strong incentives to misrepresent and to sort of inflate the value of a company, because there's each dollar more you can get for the sale of securities is more that the company will receive in proceeds. And so it's a straightforward incentive problem you have. And so by imposing strict liability, the idea is you want to sort of squash out and deter any company and anyone helping in the offering from engaging in securities fraud. Next slide, please. Oh, sorry, next. Except the challenge for implementing Section 11 is that there is a very difficult problem of standing. In order to bring a Section 11 case as a private party, you have to be able to establish that you have standing to sue, which implicates the tracing problem. Okay, if you could click through to maybe another 4 clicks. Okay, so the tracing problem stems from the requirement that the only people who can sue under Section 11 are people who acquired shares that were registered. And so if we think about the players in a traditional IPO, who might be stockholders who purchased registered shares? Well, we can establish very easily that the initial purchasers, right, the institutional investors, for instance, who bought through the roadshow, they clearly bought registered shares. You have, if anything, you have the confirmation of sale. But of course, they turn around quickly, typically, and sell into the open market. And so as a result, we think about sort of a retail investor, and this depicted in the slide. They can also establish that they purchased registered shares statistically because of the fact that the only shares that were trading in the initial market were those that were registered. Okay, so statistically, we have a 100% probability that they bought registered shares, and they would have standing under Section 11. However, after that lockup expires, if you could click through again, after that lockup expires, recall now the market is going to have basically shares that are commingled with the registered shares. And so from the perspective of the buyer in this picture, they don't know, they don't have 100% certainty that the shares that they acquired from sort of the faceless brokerage firm were necessarily registered. And so they will not be able to establish standing. Okay, so that's the problem of tracing with respect to a conventional IPO. And the problem is even more severe with a direct listing. So if you could click through, that's great. Okay. Click back once. Thanks. So in the direct listing, recall that the structure is such that the registered shares will be sold on day 1 at the same time that the unregistered shares will be sold. And so as a result, any buyer in the aftermarket, even on the first day of the offering, will not be able to establish with 100% probability that they purchased registered shares, which would suggest that they don't meet the standing requirement. And that, in fact, is what the Supreme Court concluded in the Pirani case. And so if you could just click through a couple of times. Okay, great. So, so basically, the Supreme Court just confirmed that statement I've just made, which is that the purchasers in the aftermarket in a direct listing will not be able to trace because they can't show with 100% probability that they purchased registered shares. Now, the practical upshot is that there's no Section 11 liability in direct listings. Now, it's worth noting that this is the same result that we have in seasoned offerings. Okay, with seasoned offerings, a company is already publicly traded. Alphabet, for instance, sells more shares of common stock, and if they do that through a registered offering, it's also impossible to establish Section 11 tracing in that context. But from a policy perspective, those who study this field are less concerned because, of course, this is a seasoned offering. The company is presumably already familiar to the marketplace. The risks of fraudulent misstatements are less in this context than in the context with a new issuer that is unknown to the marketplace and might be touting a disruptive technology or market, for instance. So that's why there's some concern about not having Section 11 liability in the context of newly public companies. Okay, so next slide, please. So what are some possible solutions? So if you are concerned about the lack of Section 11 liability, in either the IPO context or in the direct listing context, there have been there have been several proposals that have been floated. And so can you click next slide, please? So the first bullet here suggests that, well, we could do what's done in the bond market. Okay, in the bond market, you don't have a Section 11 tracing problem. The reason is because each bond offering that's registered comes with its own CUSIP number. It's also easy to identify bonds by virtue of the fact that they have different maturity dates, different interest rates. There's a lot of items with each bond offering that makes it easy to say this bond is clearly one that was registered on this date because this is the date at which the bond with this CUSIP was registered. You could, in theory, do the same thing with common equity. You could, well, the most dramatic form would be have two classes of equity, but you could also have just the equity trade with two different tickers. It's not something that's done in practice, but it is something that has been proposed and in theory could be done. A potentially easier path forward would be to turn to Rule 144. Rule 144 is the mechanism by which the unregistered shares are sold easily into the aftermarket. Prior to 2008, there was a requirement that anyone selling under 144 could only do so 90 days after a company had been subject to the 1934 Act. So at least you would have the ability for that 90-day period to establish that you bought shares that could be traced to the registration statement. That requirement could be reimposed in either the IPO or the direct listing context. And to note, this is the requirement that currently exists with respect to insiders. If you are a founder of a company trying to sell under 144 or a director, you have to wait 90 days to satisfy the information requirement that applies to affiliate resales. So that 90-day period still applies to affiliate transactions. The question is whether it should apply to non-affiliate transactions. Another thing to note is that under Section 17A, the SEC could regulate this through transfer agents. Recall that in order to have these fungible securities that happen that trade in the aftermarket, they have to be deposited into the DTC, and you have to have a DTC eligible transfer agent. And so the SEC under Section 17A does have the authority to regulate transfer agencies, and it's a pretty broad authority as well. So they could basically say no transfer could occur with respect to unregistered shares for a period of 90 days. More ambitiously, there have been those who have proposed, let's put this on the blockchain. On the blockchain, we'll solve all our problems because we can trace mechanically through the blockchain. I think this is probably a little wishful given the technology that currently exists, but it certainly is something that has been mentioned in this context. Okay, so hopefully that helps set the table for the conversation.
Great. Thank you, Bobby. So I actually would love to just get a check in quickly with Marie. So Marie was, Chief Legal Officer for eBay and for Agilent. So from an issuer perspective, I would love to hear a little bit about what your thoughts were in creating registration statements versus a sort of normal 10K that was not associated with an equity offering, and whether you viewed the two differently in terms of liability.
Yes.
And how that potentially, and how did it impact your processes?
First of all, thank you, Colleen. Good afternoon, everybody. Nice to see you. And Bobby, that was a great explanation. I would love it for everybody in law departments to see that, because it's a great refresher. So first of all, short answer, yes. When a company issues a registration statement and is making an offering of securities under Section 11, I believe that people really view that quite differently and take it super seriously. Not that they don't with every single periodic report, because obviously the CEO and CFO and the entire finance department, treasury, legal, there's a large or small army of people within the company that are involved in signing off, reviewing, drafting, checking, double checking all of those reports. But for a registration statement, it's a much bigger deal. And because of what Colleen mentioned, the Section 11 strict liability, I think people are super careful, and they go through line by line and they vet every statement and they think about it. And obviously, there are business disclosure, financial implications. There's a whole set of cross-disciplinary considerations that people are considering. But certainly take it super seriously from a liability perspective. And the board thinks very carefully about it as well.
Thank you. So now I would like to actually, Bobby had hinted at some of the remedies that have been proposed. We've seen a number of different potential remedies. So one, in a amicus brief to the Supreme Court, former chair Jay Clayton and then former commissioner and my other colleague at Stanford Law, Joe Grunfest, had proposed 3 possible remedies. So one, they had suggested that the SEC could require that registered and exempt shares offered in a direct listing trade with differentiated tickers, at least until expiration of the relevant Section 11 statute of limitation. Second, the SEC could adopt a narrower approach that resolves the tracing challenge only for direct offerings by requiring that exempt shares not trade until the day after an initial auction that is limited to registered shares. This would, in effect, put in a one-day lockup. Or third, the SEC could migrate the entire clearance and settlement system to a distributed ledger system or to other mechanisms that would allow the tracing of individual shares as individual shares and not as fractional interest in larger commingled electronic book account entries. So I would actually love to hear, I think, from Bob Stebbins, and your thoughts on any of the different remedies that are involved and whether this is really an issue that the SEC should consider and the importance for investors.
The SEC should consider it. First, this is my first time back here in 3.5 years. I left in 21. It's great to be back in the building. Thank you for your service on this committee. What the SEC does is incredibly important. Investor protection, cop on the beat, and it's a great institution. I know it gets criticized. The day-to-day staff here are incredible. So thank you for what you're doing. As to the proposals, I think I would be okay with any of the 3. I think Trevor's going to talk about the blockchain. You alluded to whether Trevor tells me the technology is there. The question is whether DTC and others are there, right? That'll be a question. I talked to Brett Redfern about this, who used to be the TM director. He was, there's a lot of issues, right? The one-day requirement, again, I would be fine with that. What Grunfist was talking about was doing this outside a rule context and doing this through your acceleration request. I'm not a big fan of that because I think you don't want to be in a situation where, let's say, it's a tech company that's got 100 people holding seasoned shares, and this isn't the executive team, these are the day-to-day people. You're going to have to go round up 100 of them to agree that they're not going to trade on day one, and that's messy and ugly. And I think it's just a better process to do things through notice and comment rulemaking. So I think that would be a better way to do it if you're going to do it. And the transfer agent, or the ticker symbol, the one-day ticker, the different ticker symbols for the registered and unregistered shares, again, I would be okay with that. I think what needs to be looked into, you're going to have two different securities. Theoretically, there could be two different markets. Brian could tell me, that better. He would know better. But whenever you have two markets, now arbitration opportunities exist, and they're always good at finding those and trading on those. So TM would really need to sign off and dig in and be comfortable that they could handle whatever arbitration issues exist. So you'd be creating potential headaches, but it sounds like it might be workable, but it would need to be, the boxes would need to be checked. So that's it.
So next, I think we'll go to Rob, and I know Rob.
I do. If folks will bring it up, that'd be great. And let me just start by saying how glad I am to be back here along with Bob Stebbins, who was my general counsel when I was a member of the commission. This room is special to me because when I was a commissioner, I actually taught a class in this room in the SEC's in-house university. To give you a sense of how amazing the people who work here are and why Bob's right about that, after a day of regulating the securities markets, these folks would come down at 6 o'clock to this room and listen to me. So God bless. I mean, we did a class on corporate finance, and one of my students was a guy named Mark Ueda. That was the peak, I think, of his career. So I'm a very lucky guy, and I'm very happy to be back. And I want to start by echoing what Bob said. Thank you to each one of you for being here. Before I was an SEC commissioner, I was at the Treasury and helped work on what became Dodd-Frank, which creates this committee. Working on something like that is a privilege, but it counts on people like you taking time from your daily careers and lives, and folks on this dais who are some of the most thoughtful securities lawyers there are, to take the time to try and get this right. So being here today gives me a lot of faith that the faith we had when writing that statute that you all would be here and help the SEC get these things right was rewarded. So thank you to each one of you for being here. Thank you to the staff for the opportunity to present. And if you bring up my slides, I'll, oh, there they are, okay. So I want to start with an apology because what I'm about to say is so boring. And I say that grading on the curve of the securities laws. So on behalf of law and securities law, I apologize for what's about to happen in your life. And I want you to know that I understand if not everything I say is as stirring and exciting as the rest of your day. But I'm going to make an argument today. And my argument's going to be that this is the kind of meat and potatoes problem that this committee should get this leadership to focus on. It's not sexy. It's not exciting. No one's redesigning anything. It's just solving a problem to make the markets work. And this committee's history, especially this recently, has been to focus up the leadership of the agency on those things. And I'll give you a couple of examples of why that's true. So if you just click through, I can get started. By the way, as you saw, Bobby Bartlett's the best securities law teacher in America, so I'm not going to try and redo any of this. I'll just explain very briefly. The 33 Act has imposed strict liability at the IPO stage since before the SEC existed. Fun fact, the SEC was created in 1934, but the 33 Act came the year before. So before this agency was created, Section 11 imposed strict liability for just the reason that Professor Bartlett gave. The last 10 years, some 400 cases imposed $8 billion in liability on companies that were going public because at that moment, investors are most uncertain about the company. They're not public yet. And so for that reason, having some kind of deterrence, a strict liability statute, was in the judgment of the framers of the 33 Act the best thing for investors. In the Slack versus Barani case, I attended that oral argument. Several of the justices expressed some puzzlement that the SEC didn't brief the case. I was puzzled about that too. And they held straightforwardly that Section 11 requires tracing. As a result, because of the things that Bobby explained to you, Slack, that decision, puts Section 11 at risk. Because in modern markets, tracing is hard. More on which in a moment. That's why a group that didn't, I mean, Bob, we didn't agree about everything.
No.
A lot of things.
Yeah, sure.
But not everything. But a group from Bob to Jay Clayton to Joe Grunfest to the Council of Institutional Investors to me has urged the SEC to do something. And my only pitch to you is let's not do nothing. We can talk about the technology. Trevor's going to teach us a bunch about that. But my argument is let's not do nothing in response to the gaping hole that now exists in the fundamental bargain the securities law struck. Instead, after a petition and several conversations, the SEC has so far taken no action at all in the area, and I think it's been harmful for investors for reasons I'll explain shortly. You can go ahead and click through. I want to say, for starters, that this committee recently has been really good at focusing leadership up on these bread and butter issues. Let me give you an example. Rule 10b-5-1, which governs pre-planned trade, another like super boring area, very, very important, and you guys made a great recommendation on it. And I don't know if you noticed, I bet you did, that the commission took your advice, adopted a rule 5-0. And Bob, is it me or have they been sued a couple times lately?
Fifth Circuit.
No lawsuit on 10b-5-1 because it's bread and butter, important work that had the backing of this group. And I would argue to you that this is just like that. You can click through. So as Bobby, I'm going to skip this because Bobby is smarter than me. So there's a private placement. You understand people have shares either early in the capital raising process. Typically, there can be a sale, or could you go back one? There could be a sale early in the, there could be a Rule 144 resale after the lockup. I should say, by the way, that my first exposure to lockups was when I was an investment banker. I was an investment banker at Bear Stearns back in the day. Not my fault. That was on my side of the house. But I did IPOs a bunch, and I worked on lockups. And lockups back then were very firm. 180 days, no one went to market, no resales occurred for those first 90 to 180 days. For that reason, as Professor Bartlett explained, if you bought in those days, you almost certainly got registered shares, and as he explained it with 100% probability, you could show standing for Section 11 suit. So if something in the reg statement was materially wrong, you had standing. Click to the next one. Direct listings, a different kind of approach, changed that a little bit because on the first day of a direct listing, by definition, often the company's not raising capital, folks are going to do sales early in that process. You can click again, please. As a result, there's going to be immediate resales. Can you go back one? There's going to be immediate resales into the direct listing. So it's not surprising in a way that the lockup periods have begun to disappear. Because in a way, those who run traditional underwritings have to compete with this new product, this new approach, and they have lots of competitive pressure on them to waive lockups. As a result, a group of academics from Wharton, UVA, NYU submitted a petition over a year ago letting the SEC know about this issue. Next slide, please. The working group provided a bunch of data. It was called the Working Group on Investor Protection and Securities Offering. Provided a bunch of data showing that this is a real problem. On the left-hand side of my slide, I'm just reproducing what they did. You can see that almost no lockups were waived by the underwriters back in 2004, 2005, back in the day before I was on the street. But recently, lockup waivers have become more common because the company comes to the underwriter and says, we know you want to stabilize the price, but I need liquidity. I want to be out of this thing. So they waive the lockup. By the way, you can also see that in the Rule 144 data because 144 notice is provided of an intention to sell. And as the working group document is here, those notices often come way before the lockup is meant to expire. So lockups are being waived. As a result, unregistered shares are coming into the pool and people lack standing. Next slide, please. Oh, lawyers. So as a result of enterprising lawyers who know this is true are actually advertising online the service of avoiding Section 11. This is a post from the Harvard Law School Forum on Corporate Governance. The title is A Modest Strategy for Combating Frivolous IPO Lawsuits. Because if this lawyer's hired, the suit must be frivolous. So what this says is, hey, call me. I work at Wilson Sonsini. Call me. We will get unregistered shares in your pool early, and when you face a Section 11 suit, we'll seek to have it dismissed on standing. Now, maybe it's just me, former commissioner, I don't know, America, but it doesn't seem great that lawyers are advertising a way to evade the principal deterrent statute at the initial public offering process. And so the working group that filed this petition explained how they might do that. Next slide, please. By the way, I thought we could play a fun game, this being the most boring subject ever. I'm going to give you some quotes to give you a sense for how bipartisan it is that the SEC can't do nothing here. And I want you to try to guess who said that. Sound good? Okay. Because these are like denizens of liberal financial policy making. Okay. The SEC could resolve the tracing issue by requiring that exempt shares not trade for a given period of time. Who said that? Elizabeth Warren? What do you think? Can you hit click once? No, that's Jay Clayton and Joe Grunfest. Not known for thinking we should rewrite the securities laws. How about this? The SEC has ample tools at its disposal to address the concerns that have been raised, including imposing a lockup period. Who do you think said that? Maybe it was me or something. Who? Click again? No, that's the petition in Slack versus Perani. Those are the guys who won the case, saying, hey, we think that there was no tracing here, but this can easily be fixed by the SEC. How about this? What all this means is that the important investor protections in Section 11 have been significantly undermined. It's time for the Commission to update the regulatory framework. That must be a real reformer. Click again. Council of Institutional Investors, not known for making stuff up. How about this? This was said at oral argument at the Supreme Court. I watched it. I thought it was so interesting. So that's the kind of an institutional argument where the Supreme Court can just leave this to the SEC. What justice said that? Justice Jackson, my personal favorite. Justice Sotomayor? Click. No, Brett Kavanaugh, friend of the administrative state. So there is a huge agreement among all observers that it doesn't make sense to allow this hole to exist in our federal securities laws, which is why we think doing something about it is important. Next slide, please. So here are some options that have been put on the table. I'm going to briefly talk about them. First, Trevor's going to say a lot more about this. He's forgotten more about this than I've ever known. And he took a red eye to get here. So I'm going to not say anything about that. Bobby, as Bobby Bartlett mentioned, doing this by multiple QSIPs around the blockchain sounds very interesting. Trevor says the tech can do it. The problem is there's all kinds of intermediaries who have an interest in not doing it. The DTCC, the exchanges, et cetera. And my experience was bargaining with them. Bob, how'd that go? The exchanges? Yeah. The New York Stock Exchange, my favorite day at the SEC, I came into work. The Wall Street Journal had a headline on it. It was an op-ed by the president of the New York Stock Exchange saying why we're suing the SEC. And I was like, subtle. So coordinating that with the exchanges and DTCC would not be trivial, even if the technology is there. And he says it is, and I think he's probably right. Next, click, please. Here's something else you could do. There's litigants right now facing dismissals on the basis of standing. So people are right now trying to discover who bought what when and do the brokers, who possessed what share at the brokers, and they're trying to prove that. So they've been issuing subpoenas to brokers and to others to try and get those data. What the SEC could do is support that. They could write an amicus brief saying, yeah, give them the data. Or they could provide data the SEC has on the subject. Not only has the SEC not done that, they've actually filed a brief refusing to provide certain data to litigants that could help them prove standing. So the last option is the one that I'm going to focus on now, which is to reform Rule 144. To fix the rule to address the hole that the market has created. What you would do is just say, after an offering, there's going to be some time during which you can't sell. I agree with Bob that the best way to do this is probably through notice and comment, although Joe's proposal is an interesting one. And I have to tell you, I've been having conversations with the SEC about this now for over a year, and it's been surprising the answers I've gotten. Because I'm going to explain to you shortly, the arguments I've gotten candidly don't make much sense, but more importantly, they reflect a lack of prioritization of the issue, which is why I'm here today. What I've heard from the SEC staff about this, just to preview it for you, is that, well, if you do this, people might sell unregistered shares anyway. Because even though they don't have the Rule 144 safe harbor, they'll just take their chances. I mean, maybe. The reason we have a safe harbor is because people don't want to take that risk. Also, their brokers would be taking legal risk. But anyway, that's all. Even if it's right, that's not as bad as what we have now, which is lawyers online being like, "Call me to avoid Section 11." There's some risk that tracing is. There's some possibility that tracing can already be done based on probability. More on that in a moment. And this is wild. I keep having people tell me the SEC doesn't have authority to act. I mean, Brett Kavanaugh thinks you do. Anyway, I'm going to come back to that. So next slide. The concerns that I've heard so far in response to this petition are ones that I don't think should be taken too seriously. One, for example, if you could click, as I said, one is that sellers are going to sell anyway. That's legally risky. Their brokers would be taking legal risk. And it's true that this isn't a perfect solution, but even the Constitution endeavors only for a more perfect union, not a perfect one. And this solution beats no solution. Next slide, click, please. There's a possibility that tracing can already be done by very large holders on a probabilistic basis. So let me give you a quick hypo. Suppose you buy on the first day, and there's 1,000 registered shares and 100 unregistered ones. And someone buys 500 shares. And they come to court and say, I must have some registered ones because there's only 100 unregistered ones. So by probability, I must have some. Now, it would be a sensible solution to the problem if that were the law, but wait, it's not. The Fifth Circuit said 20 years ago in a case called Crim that probabilities are not enough for tracing. You have to show that you can actually trace, and the Supreme Court recently affirmed that. In Slack, if you want, you can take your chances in the Fifth Circuit. How's that going, Bob? Next, please. The SEC, the other argument I've heard is that the SEC can't re-restrict shares that have already been unrestricted. So the risk is we're afraid we're going to impose obligations on people who already have freedom to sell. For one thing, the SEC's already done this in 2008 under Chris Cox with respect to shell companies. But from another, just to back up, remember, Professor Bartlett taught you that Section 5 says you cannot sell shares in interstate commerce unless they are registered or under an exemption to registration. And the exemptions are set by the SEC. Congress says you can't do this. The SEC makes the rules as to when you can. I don't know of any clearer grant of authority that exists in federal law, and certainly in the federal securities laws. Next slide, please. So, I could talk about that in the Q&A. Click next, please. Just to wrap up, I've been too long, but the short version is this is a serious problem. It's a boring problem. It's a problem that no one would hear about. It's a problem that no one would be blamed for not fixing, but it is a serious meat and potatoes problem of the federal securities laws that people are going online advertising, call me to avoid Section 11. And so my pitch to all of you is, as you have done so successfully before, point the SEC's leadership to something that's not sexy, not fun, but important to the operation of the markets. And I think this committee would do investors a great service by focusing them on solving a problem like this, especially one where a bipartisan team agrees that some solution is desirable. Thanks for having me today.
Okay. So thank you, Rob. So I would like to go to Trevor, and then after that, I will give the panel, if any of you guys have additional comments that you would like to add, and also I'll open it up for Q&A from the IAC, and then after that, we'll go to our second topic. But Trevor, so I think you know where this is going, given you are, blockchain expert. But as Rob actually mentioned, CII had filed a comment letter following Slack, and they said, this is a case that we hope the commission takes seriously and we hope they look into it. But this also highlights yet another issue with the general framework that we have. And in the CII comment letter, they specifically said, we would respectfully request that the commission add a project to its rulemaking agenda requiring the use of technology that would facilitate tracing to deal with situations such as in Section 11 cases. But I think there's a question of whether this is really practical, if it's feasible, and at least if we're talking about the technology itself, can this be done? So if you could talk to us a little bit about that.
I'm happy to. Also, a very easy act to follow. Thank you.
I should also mention, Trevor, I also not only took a red eye, but also recently had a baby. So thank you again for coming.
Yeah, thank you. That was part of my notes to say that I have a 6-week at home and I have not slept. So I'm looking at court cases and I'm like, wow, you guys are smart. The TLDR is yes. I think that the technology is at a point right now using blockchain, just the technology. Now, everything with the DTCC and all this other stuff, that's not my area. But in terms of being able to track and differentiate shares, yes. Also, blockchain allows you to not just differentiate, it also allows you to program. Let's say there was some kind of break in time, right? So let's say you want to have 24-hour break or a 3-day break, whatever. You can actually program that into the NFTs, the fractional NFTs that would actually allow you to differentiate the different pieces. That exists now because my platform uses it. So I think that I agree with Clayton and Grunfest, and then also they mentioned Richard Pan's paper in their brief, and that was actually really helpful. That's a very good overview. There's been quite a bit of new updates within blockchain in the last few years that would actually allow this to become a lot easier. And I think the way that blockchain is evolving very quickly. So just as it is right now, I think on a go-forward basis, having a team of people looking at how to be able to fix this and do so in a way that makes sense with the external factors is more than doable. And I also think that we can take whatever recommendations that would come out from this committee and then be able to take that to any technologist, and I think it actually code that into NFT. So I think that you can do that. You could have them as different QSIPs, you could have them at different break times, and it would all actually end up being able to work.
Thank you. So first, are there questions from the committee? Yeah, Brian Helmer.
Thank you, everyone, for coming in. The implication in the testimony was that we could be of service to this cause by just raising the priority of the issue and putting more gravitas behind it. And I appreciate the compliment that anything we did would be able to do that. I am struck, though, by some of the responses that you talked about. To me, it implied that there's something more going on than just a lack of prioritization. Is there any issue, any constraint, any hurdle that needs to be overcome to actually see action on this that wasn't directly mentioned? Is it just a matter of priorities, or are there other things in the way, that other lobbying forces, other issues and constraints that are preventing this from happening? I'd like to address them in our recommendation if we can.
Well, sure. No, I think it's a great question. I have to tell you, I'm puzzled. I don't know.
Okay.
Is the right answer. I wish law professors said those 3 words more. I don't know. I will tell you the answers I've been given reflect a very, very risk-averse version of the SEC's authority. It was quite an experience to be on the phone with the folks who helped write the climate rule and hear that they didn't think they had authority to deal with Section 11. Whatever you think about the climate rule, and I've got thoughts, that was an experience. So that's why, sir, I think you're right to ask what might be going on, and I don't know. What I do know, look, just to be really clear, Bob and I worked here. It's really hard. Like, they're overseeing $40 trillion. And the people in this building work incredibly hard doing that. I would understand. If the answer were, hey, we don't have the resources, I would understand that. But the legal arguments that have been raised, we don't have authority, we can't re-restrict, people will sell anyway, those are not, in my view, those are not serious legal arguments that are reasons not to do this. And just to be one more thing about that, remember that the world we have is one where people are advertising online the service of evading a federal law. So I'm comparing to that, like I'm grading on a curve. So compared to that, like dealing with some of this seems better to me. But I leave to the committee's sound judgment whether that's right.
So I just think as to the politics behind it, there's a big difference between 1 day and 90 days, right? If you write the rule this way. 1, to me, gives you the deterrent you're looking for. I mean, I have done securities law for 30 years. I mean, I spend as much time and work on the 10K as I would on the S1, but let's posit that you're spending more time on the S1. You'd still have your deterrence, and you're not keeping the rank and file out of being able to trade. So if you go 90 days, then it's going to increase the number of plaintiffs, right, which the bar will like, right? The plaintiffs' bar will like that, right, as opposed to 1 day. So it's better. So it becomes political in that regard, right? So companies will prefer 1 day. One of the downsides of 1 day is that if you're the assistant treasurer who's not on a lockup and you've been working at the company 3 years, you can't trade after the IPO for 90 days, right, which is not really what we're looking for. Everyone else is trading it, you can't, right? So where do you draw the line? I draw it one day. I'm sure others will draw it differently, but that's a serious issue, okay?
Sorry, just to add, Bob's, as usual, absolutely right about that. And so, the exact amount of time, but that's just to connect to another thing Bob is right about. That's why a notice and comment process would make sense, because you get feedback on that. There's going to be academic work on it. The market will come in, people will have views, and then the commission makes the decision, which is usually how things work when the SEC is doing its job.
If I can just quickly add on that too, is I do think that that there's some concern about the law of unintended consequences here, because 144, if the intervention was made through 144, there could be a concern that there's going to be a repeat of what happened when they amended 15C211, which is that they hadn't thought about the bond market or think about the OTC equity market, and then all of a sudden they had a big issue which they hadn't thought about, the disruptions in a very large market in a way that they hadn't anticipated. So I think if they do, to the extent you make a recommendation, I do think it needs to be very narrowly tailored to focus on this specific context. And so practically speaking, what that would translate in my head would be basically there's this moment where where securities go from basically being sort of identifiable, even certificated, to being basically fungible and tradable. And that all happens when they get deposited with DTC, and when you get a transfer agent that is not CARTA, but is CompuServe, it's a transfer agent that is DTC eligible, that's when the restriction would apply. And that way you would get rid of concerns that, we're going to disrupt sort of the market for sort of 144A or for bond trading or for NASDAQ private market. It could be focused on that context.
So on the queue, I currently have Paul, Andrea, Jennifer, and James. If anybody else would like to jump in, please let me know.
Okay, thank you guys. Great presentations, great discussion. I agree that this is a very important issue for the commission to deal with. And I guess as we consider making the case to the commission, SLAC comes up in the context of direct offerings. Are there other contexts that we could point out where tracing is important? And I'm thinking about successive offerings, securities already trading, shares trading after, before an IPO that are already in the marketplace, DSPAC, registration statements that might be defective or somebody wants to make a Section 11 case out of that. I mean, are there other cases, other situations where we can highlight where this issue is important and should be addressed by the commission, but beyond direct offerings?
I'll jump in. I don't know the data as to whether there's a problem that exists. In theory, I know that it doesn't have to be a direct listing IPO. You could have seasoned shares sitting there, and you could have a tech company or any other company that's providing the current public information. This happens a lot now. So these successful private companies there's a market for their shares, and so there's information being provided. So as we talked about Bobby's presentation, day one, they're able to trade right away. This isn't just a direct listing company. This could be any company, right? And is there a problem? Is it happening a lot? I don't know the answer to that, right? I know the direct listing one hits you in the face as a problem, right away, because they're coming in and they're doing the 144 shares together on the same day, day one. On the other shares, you've got a lockup, right? But the lockup might not cover everybody who owns the shares, right? And we also talked briefly about them being waived. But it's not just waivers, it's other people who hold them, right? It'd be people who aren't executives but hold shares that they can trade day one. And as soon as they start trading them, everything's fungible, you can't trace. Now, is it a problem outside the direct listing? I don't know. I don't know the answer to that.
Let me just say, so I think your question is very important because there's a couple of separate categories of transactions we can think about. So first is, I'll put direct listings and IPOs in the same bucket, because even a traditional regular way IPO, because of lockup waivers, has the problem. So to me, those are very similar cases and would require a similar solution. But you're asking the harder question, Paul. You're asking about what Professor Bartlett described as a seasoned equity offering. And here, I want to say that the 144 solution would not work, would not do much, because there's already stock in the pool, and some of it's going to be registered and some of it's not, and there's nothing to be done about that. Professor Bartlett made this point. I think it's a really important one. as we're weighing, Brian, the various pros and cons here, notice that Professor Bartlett's law and economics analysis was that because those companies are already public, the information problems investors face are different than at the IPO stage. The IPO stage, they have information asymmetry. This is a company that's never been public, but Google doing an SEO, we can talk about how we feel about that, but Google doing a successive offering, that's a pretty well-informed market. Now, what could the SEC do about that? Well, the cases I'm familiar with are ones where academic economists are trying to use the data to figure out from broker-dealers who owned what when, and can we trace back from a secondary market that's got both kinds of shares to a registration statement. And to make that work, the SEC would have to be willing to go to court and, as an amicus, say to the court, you should allow discovery of what's going on in these broker-dealers so that people can know what's happening. Now, that's a different cost-benefit calculus, both for the reasons Bobby gave and the one I just mentioned. I leave to the committee how to balance that, but that's how you would deal with that separate problem.
So I'm curious on the panelists, if there's a compromise solution, so you reinstitute the lockup, but a way to get out of that to provide a liquidity valve is if they do the blockchain tracing. So that would provide incentives for them to use the technology that exists, so that it's not an either or. You can have liquidity and an incentive for tracing.
Deal. I mean, seriously, just to be clear, like my own view, that's really interesting and creative. I'd want to encourage people in that direction. By the way DTCC and the exchanges are going to get there is when companies get there. And what's very clever about your solution is that you'll nudge companies to nudge them, so I'm all for it. Anything that's not nothing, I'd be thrilled.
Yeah, two questions, and I think one of them was largely answered already, but I'm going to ask it anyway. Because when we're talking about the direct listing context, one of the advantages of direct listings is that every share goes in at the same time on the same auction. Talking about instituting a regulatory lockup there changes that calculus a little bit and changes potentially the desirability of a direct listing. And I'd just be curious to hear thoughts about whether that's a potential issue or not one, and maybe that depends on the length of the lockup. The other question is, when we're talking about DLT, where does that leave us? So you have a differentiated share, you know it's a registered share. Does that leave us with Section 11 traceability forever? How do you cut that off? We start looking more and more like certificated stocks and less like street name. Where is the Section 11 kind of limit if we're using DLT to trace registered shares?
Well, there's a technical answer in the 33 Act, which is that there's a statute of limitations, and then there's also a period of de facto reliance defense that can be applied. So if basically a year of financials passes, then you're not going to be able to bring a Section 11 case. So it would sort of solve itself to a certain extent, assuming that you're comfortable with having liability for that first year of the financials.
Well, I say it looks a lot longer than what we're talking about in the general IPO context now, where you're talking about a 180-day lockup in this traditional system. We're talking more about the full statute of limitations, which hasn't really been at play for a long time.
It's also worth noting, too, is that the damages are with respect to the offering price. And so if the stock trades above the offering price, then there's effectively no liability. So it would really be, in some sense, the class of cases where the stock trades below the offering price, or there would even be any damages, which is sort of another way in which I think it would constrain the scope of liability.
And as to the first issue you raised, it's a real issue. It's kind of what I was getting at, and I think you need to take it into consideration, and that's why Professor Grunquist really is recommending a minute as opposed to a day, because he wants people to get out there and be able to trade together, as soon as they can with the people who are receiving the IPO shares, right? You want the people the employees who've held the shares, which is what we're talking about, being able to trade with the big hedge funds as soon as they can, right?
Just one quick thought about that. I think that Bob is right. That cuts toward a shorter, not a longer period. I guess I'm curious, to the degree that we think direct listings will become popular because there are regulatory arbitrage around Section 11, that would be a little worrying, I think. Because I could go on at some length. So I think we wouldn't want that. But you're right. Jennifer. It's a good point you're making that, and this is why I'd want notice and comment rulemaking. Because I'd want the people who do DLs to be able to come in and say, yes, when we market these, we can 20 days is livable, or isn't. And here's the data on how, So that's why I think going through the full process makes sense.
So we've been talking about this, but it seems like a shareholder in the market and is relying upon a 10K should be protected. But it seems like there's a big difference between what the S1 and the 10K. Can you unpack what's the differences in protections for a shareholder under those circumstances?
Well, 10K, I'm not positive I have the question, but let me just go through the 10K versus the S1 big picture. If you're going to sell securities, everything material about your company needs to be in that document. There can't be anything that's not material that's in there. 10K, you only have to put in what's required, right? So it doesn't have to be everything that's material, right? So to me, that would be the main difference between the two.
I would just say, could I just add, practically speaking, I don't think the CEO and CFO think there's a huge difference because they're still signing the 10K. Their personal names are on there. Believe me, they pay a lot of attention to what's in the 10K. You have your directors signing them too, or I think it's technically a majority, but all the directors generally sign. And there are certifications and sub-certifications throughout the company. And there's a whole process to make sure that what is in the 10K and the Q and the 8K or whatever it is accurate and complete.
And I think that it's one of why we want more public companies, right? Because it is a good, healthy process that gets information out. An example of what I'm talking about would be, let's say there's a pending merger, right? You're not putting that in your 10K, right? But you're not doing an S1. You can't go sell shares if you're about to do a merger, right? So that would be an example. 10K, only what's required to go in. It doesn't have to be everything material.
All right, great. Thank you, guys. So for this panel, the idea was let's go through some key court cases recently. So the first one was Slack. The second one, actually, for the remainder of the panel, I would like to discuss Exxon versus Arjuna and just, proxy proposals. So, and the potential implications of Exxon versus Arjuna. So Bobby's going to give us a summary of the case. But also, just before we get in, I think I just want to give a couple key statistics on proxy proposals. So there, obviously a concern that do we have too many proposals? Has the number skyrocketed? Just a couple key stats. So right now, the S&P 500 receive 90% of the proposals. So a lot of the time when we are talking about companies getting a multitude of proposals, we're talking about those very large companies. Of the S&P 500 companies, 56% received at least one and 8% received 5 or more shareholder proposals. Over the past year, we've seen the area that's had the greatest increase of proposals has actually been the anti-ESG proposals. And we've seen a huge increase in that area. Another kind of key stat that I think is actually really interesting is more than half of all submissions are from 10 entities. And there's one person in particular who is responsible for 199 proposals so far this year. So we've also seen a big increase in the SEC's no action process this past year. And I think this brings us into Exxon versus Arjuna, where instead of going through the SEC's process, we saw Exxon just sue one of their shareholders in court. And so, Bobby, if you would like to start.
Yeah, sure. So I think the facts are actually pretty straightforward. So, the basic background is that you had two shareholders of Exxon, Arjuna Capital and Follow This. Arjuna Capital is a U.S.-based group, and Follow This is based in the Netherlands. And they proposed a 14A8 proposal that was encouraging Exxon to go beyond its current efforts to reduce carbon emissions. And it was very similar to a proposal that had been made both the prior year and the year before that. Ordinarily, as you're no doubt aware, the standard practice for companies that would like to exclude a shareholder proposal from their proxy statement is to go to the SEC and ask for a no action letter. And instead of going that route, they just went straight to the court to ask for a declaratory judgment that they could exclude. And so that was why it was such an unusual maneuver. And in the complaint, Exxon largely set forth what would be ordinarily just an argument for exclusion that they would make to the SEC, which was that this relates to ordinary business practices, and that it also doesn't meet the resubmission exception, which is that if you are going to resubmit a proposal that is substantially similar to what you did before, you can only do so if in the prior year it had received a certain threshold of votes, which this proposal had not. And then they also explained why they took this route, and that was in some sense because they were concerned that the SEC's policy on reviewing 14A8 no action relief had changed in a fashion that they were no longer confident the SEC was applying a consistent approach to these requests. And so that's why it went to this extraordinary effort to go to court instead of to the SEC. The ultimate outcome, probably doesn't surprise you, that Arjuna, and followed this, immediately withdrew the proposal, trying to moot the claim. That actually didn't work initially, and that was because Exxon was able to convince the court that they would just resubmit it in the future. Ultimately, the court did follow this because for jurisdictional basis, and then dismissed this summer Arjuna after Arjuna committed to not resubmitting this proposal in the future. So that's sort of a summary of the facts.
Thank you. So I'm going to go through the panelists, and I would just like to offer each of you guys the opportunity to provide any comments that you may have on shareholder proposals generally or Exxon versus Arjuna. And then after that, I have some questions that I'll ask the panel broadly. So I guess, Rob, let's start with you.
Sure. So this one Bob and I are going to disagree about. So when I was in office, the commission chose to make some of the changes to the rules that Bobby described, and I objected. And I said, you're going to politicize a process that is inherently political, and it's a bad idea. I said that in my dissenting statement. I said it privately, and that's what happened. So the previous administration took the view that fewer shareholder proposals were better. So we adopted rules over dissents to make it harder to make a shareholder proposal. This administration thinks more proposals are good. So now we have a situation where proxy statements have very many proposals. I opened one last night preparing for today, and there are proxy statements with 30 or 40 proposals. I don't know how many is too many, but that's too many.
Company was that? What issuer?
I'll take a look. I think was it Apple? No. I'll take a look. James, I'll send it to you. 30, 40 proposals. Yeah. So that's a lot of proposals. And the reason, of course, is that the SEC is hesitating to provide no action relief. So I think my own view about this is that what we should be doing is instead encouraging negotiation between the issuers and proponents outside of the SEC context. So what we should be trying to do is say to the company and its shareholders, try to work this out. Because, and I should give full disclosure, I wrote an article about this with Colleen. The evidence shows us that bargaining between shareholders and issuers leads to the most valuable kinds of outcomes. For example, shareholder activism often leads to agreements to settle rather than have a proxy fight with representation on the board. So if I were the SEC, I wouldn't be trying to make a judgment about whether more or less is better, about whether if you got 5%, that's enough or too much. I wouldn't do any of that. What I would do is adopt policies designed to encourage companies and shareholders to work it out, treating the SEC's process as a last resort. That would conserve SEC resources, allow them to give more alacrity to the no action requests at issue that they want to deal with, and I think would avoid a very unfortunate situation, because let's all agree that whatever you think about what happened in Exxon versus Arjuna, companies suing their own shareholders is unusual and not the ideal situation for our markets.
So let's go Bob, Marie, and then Trevor.
Okay, so these aren't new issues in general, although there certainly are more proposals in the last few years than we've ever seen. But in the 1998 release, they batted about this social good concept and whether the SEC should be letting people make exemptions and making determinations about whether something is socially important, and thus going in the proxy statement whether it's related to your business or not. And they say in the adopting release that corporate America thought that one way and shareholder proponents thought the other. So this has been out there as an issue for a very long time. And basic principles, if you look, now we're no Chevron deference, remember, anymore. So in a 1993 Law Review article, Professor Fish, who is no Republican, said the statutory language and legislative history are ambiguous as to whether the SEC is authorized to enact rules with a substantive effect on corporate governance or simply to implement disclosure requirements. This is raising its head again, and serious people, not just bomb throwers, but serious people are thinking about whether the SEC has any authority to do what they've been doing. So these claims are potentially out there. I actually think that having the SEC involved is a good thing, and I would not want to see them outside this. I would just like to see it reformed. I don't think that the current structure is working very well. I don't like the idea that, from a big picture, the SEC has somebody in CorpFin determining whether something is an important social good, and it's going in your proxy statement whether it's related to your business or not, and you're paying for it. I think that's a very ugly argument to make in the Fifth Circuit. I think when you just talk of the last 25 years, it depends who's in office, regulatory ping pong, a little more proposals, a little less proposals. That's worked pretty well. But if the courts come in and give you a result you're not going to like, then there's no more regulatory ping pong, right? Now we're going to have a whole new structure, right? So I think the SEC has to be very careful about where they're going with this at the moment. And I think there's a lot of risk they're bearing. And I'm a little concerned about it. There's the Kroger case that's down there in the Fifth Circuit right now. Now that is kind of styled more as a First Amendment case, which is a better position for the SEC to argue. But I think it's risky ground that they're at the moment. I think that, in my view, what we had done with getting the board more involved for a company is determining whether the social goods relate to a business and less just the staff person making the determination whether it's important. I thought that was good. That took the CorpFin out of it a little bit. I thought it was legally going to be more defensible, so I thought that was very wise, and I thought changing that was not great. So I do think that they need to do something in that area, and also about making there more of a realistic appeal process, timing-wise, to be able to get to the courts. The way the date's set up now, you really don't have a situation if the SEC says no. They say, oh, you can go to the court. Well, there really isn't time to do it. So I think doing something that there is a more realistic appeal process sounds good to me. I like what Commissioner Jackson is saying about talking between the company and the shareholder. I do think that happens a lot. I think it happens already. I think it's been happening more and more. And obviously, talking to your shareholders is never a bad thing. So that's it.
So we'll go, Marie, I see you have your microphone on, so great.
So I want to provide a little bit of the practical background of what's involved with the proxy process and shareholder process inside a company. And you may already know this, but it's more than a 6-month process from start to finish, from the time you start preparing everything that's involved in preparing your proxy, getting your officer and director questionnaires, talking with your shareholders, drafting the proxy statement, all the tables, figuring out the disclosure, drafting, getting the appropriate review, understanding the different timetables, the windows for the shareholder proposals, and then there's a different window for potential nominees for the board. And the shareholder proposal process has been pretty difficult for issuers, I would say, over the last number of years. You heard from Colleen some of the stats about the numbers of submissions and no action requests being granted, not granted. It's been pretty unpredictable for issuers lately. That makes it tough. This is not just something that the legal department deals with either. This is something, as you can imagine, especially with the escalating social, political pressures, geopolitics, the pressures on companies to speak to various stakeholders on different issues. And so you have committees of the board getting involved. Probably the compensation committee bears the heaviest burden when it comes to the proxy statement for obvious reasons, executive comp and others. But when you get, in some cases, as Professor Jackson alluded to with some companies, getting really just bombarded with a ton of shareholder proposals that are really not relevant to what a company's core business is, or its material risks, or what the long-term value and prospects of the company are, it takes a lot of time and resources, and not just at the mid and lower levels of the company, but it also raises questions on, like, what is the overall purpose of this? How is it serving shareholders? How is it serving the financial markets? How is it creating better disclosure, if at all? And I'm not saying that that's true for all proposals, but there's been a real increase over the years. Now, there have been ups and downs on shareholder proposals that really, if you look objectively at them, don't really relate to what you would hope a reasonable investor would care about for the company. And so it's not just the expense, but it's the broader questions on what is the overall benefit to investors for some of these shareholder proposals. And I don't have the silver bullet that will fix the proposal process, but I think there needs to be greater predictability for issuers. There needs to be simpler, cleaner, faster processes to get answers, because there are real deadlines and implications for companies on how to deal with this.
James, just to get back to you, it was Google and Amazon, which had, in 2022, yeah. By the way, I should say that the trend I mentioned earlier has changed. It was a little lower in 2023. So even in those two companies I just mentioned, James, the total number came down. I want to just throw out a policy idea. I'm not nearly as convinced about this as I am about other things, but one thing the SEC could do would be to encourage the kind of discussions that Bob just mentioned. I think well-counseled companies, when they get these proposals, often talk to their shareholders. But there are others who don't, and who come right to the SEC, putting them in the very difficult position that Bob was just describing. I agree with Bob that the SEC should have a role, but that role has recently changed a little bit with the political winds in a way that creates uncertainty for people who are running real businesses. So a suggestion we might have is something along the lines of having a staff with limited resources prioritize requests from companies that have tried and can certify that we've tried to work this out with our investors. Again, there's lots of complication there. I'm not suggesting that's a solution to the problem. What I do want to say is what the literature shows is that bargaining between shareholders and companies is valuable, and to the degree the Commission can encourage it and avoid consuming our own resources with litigating these kinds of difficult contested social and other policy questions, maybe that's something worth looking at.
Yeah, and I do think that most well-counseled companies do try to speak with the proponents of the proposals. They try very hard, and they make multiple attempts before they try other things.
So I have a series of questions for the panel, but also I realize many people on this committee have strong thoughts on, the proxy process. So if you would like to jump in and ask a question, please just let me know so that I can add you to the queue. So first, though, Bob or Trevor, Bobby, if any of you guys would like to add additional comments just based on what you've heard, please feel free. Please jump in.
Just a quick idea is from the non-lawyer perspective. I'm looking at how do you get something done. So I'm an entrepreneur, so I have to get things done quickly. Is there not a reason for why we couldn't have a database that would show proposers of the proxy and see what they've done over time within different companies, what they proposed, and then how successful they've been, and then add that to the proxy, right? So that we could have a database, and then it'd be shown if there's a large concentration at the top of proposers, those folks should be known when someone's making a proxy vote. And the same thing could be done at the company level, where the company would say, okay, we get these many things a year, but the same things over and over again, and we've only done 10%. So that way, anyone that's voting would also know that as well. And that might make it easier for investors when they're making their votes to be a lot more transparent. And it's consistent across all companies. So it doesn't have to be on blockchain, just regular technology, but much easier to do that way.
So I think that's also speaks to some of the empirical work in this area, which I would note. In general, if we look at, say, long-term value, like, total shareholder returns, if we see a company following a shareholder proposal, if that proposal comes from a so-called gadfly, a lot of times we're going to see negative returns thereafter. Whereas if we see companies that are responsive to proposals from other investors, a lot of times we see positive, abnormally high returns thereafter. So I think thinking about who is submitting the proposal and their history is a great idea. Now I'll get to the queue. So first we have George.
Yeah, this is very, very interesting. And I kind of want to underscore a couple of facts about the shareholder proposal process. And I think the most important fact is that these proposals are merely advisory. They're precatory, so nothing obligates the company to actually do anything in response to the proposals. And then even with respect to inclusion in the proxy statement, the proponent of the proposal is limited to 500 words, whereas the company can actually take as many words as it wants to respond. So, I know that there was some kind of skepticism from Robert and even from you, Rob, in terms of the optimal number of proposals, but isn't it the case that if we have to set a boundary, this is a case where we would rather have an overbroad rule rather than an underbroad rule? I'm thinking back to the PG&E case from 1986, where a plurality of the Supreme Court said that the shareholder proposal process is speech by a corporation to itself. And with really large corporations, they can't take the pulse of all their shareholders. And yes, many of these proposals will be meaningless, but there may be something that isn't meaningless and isn't that worth highlighting. And at the end of the day, of course, to get any traction, they have to get some sort of a majority, either a recommendation from the proxy advisors or from the other buy-in from the other shareholders. And if it's really such a bad proposal, they will be unable to get that traction. So what do you say to that?
I think it's a great question. So I actually think there's such a thing as too many shareholder proposals, and let me say why. The reason is that investors, by definition, have limited time and attention. So there's only so much that you could ask an investor who's diversified, who's got their own expenses. You all got jobs, it's busy. There's only so much time that you can give to reading a proxy. And the proxies I mentioned earlier to James, if you look at them, they're wild. They're actually fun reads, because it's like the ESG proposals are like, do this, do this, do this. And then some other guy's like, don't do that, don't do that, don't do that. Now look, I am a very, I think folks would agree that I'm a pro-shareholder type. But there is, what I want is the right balance between things that shareholders can understand and give input on. I think that's extremely important, and surplusage that taxes shareholder resources. So I do think there's such a thing as too many, and the question is where to draw that line and who should draw it. One more thing, George. My concern right now is that because folks have strong views on either side, we keep doing this. Just depends who's in office, right? And the scary, when I used to work here, the thing I would listen to, I would ignore a guy like me. You should listen to Marie. What Marie said was, first, I take registration statements seriously. Great. That's the most important thing I heard today, so I'm going to tell my wife when I get home, because that's the law I want. She also said, it's just all over the place. I don't know what the rules are on shareholder proposals. And I think it's incumbent upon the agency to try and provide some stability in that respect. Even if it's not the policy I would choose in my first cut, I would want a stable policy so that people can run their businesses and investors can speak their mind on the subjects that are important to them.
Can I add one other thing? And thank you, George, for your question. I think these days, too, compared to when I started at my first company, Hewlett-Packard, board members are speaking more frequently and directly to shareholders than they used to. So that's a good line of communication that has increased over the years, if not decades. And second, if you look at the stats, the number of proposals being submitted to vote has gone up. But I found it a really surprisingly low percentage that actually got majority support, and that was 4%. If it's that low, that suggests to me that something is wrong. And so I think there needs to be a balance. There needs to be a way for shareholders to submit meaningful, relevant proposals, but not so many that you get drowned out.
Can I just say one thing, which is that I think the 4% is really stunning, but I think there's an explanation for that, and it is that the best proposals get settled, so they get taken out of the denominator. So you really are getting votes on only the bad proposals, and you would hope that they would get low levels of support because they're bad proposals. And if it's a good proposal, it kind of reaffirms what you were saying, that there's a dialogue between the companies and the board members and the shareholders, and then there's hopefully some action as part of a settlement.
And I'll just sort of align myself, I think, with what maybe this general sentiment of the panel is. And I feel that the cost of having a really robust system of 14A8 is that it does politicize the corporation. And I think that is typically something that most shareholders would prefer not to be the case. I think you might care about the externalities that a firm has, but in some sense, I think many people think, well, maybe the proper way is not necessarily through sort of politicizing the corporation, but through other instruments, Peruvian taxes or regulations. And so I think the proposals that do get settled are the ones where the management says, actually, that's a value-enhancing proposal, and so we can get on board with that. And the ones that end up showing up in the proxy are the ones that tend to be political, is I think, one way to describe it. And I think that's a cost in the system, from my perspective.
Yeah, I think that's a really good point you raised, Bobby. And when I was preparing, I was reading some of the background that, you can correct me, but I understand the SEC previously didn't think it was appropriate for corporations to delve into politics, and under this whole process would exclude proposals that were more political in nature. Now, I know the social dynamic and the externalities facing companies has really dramatically changed recently. And there certainly are some companies, probably by virtue of who their CEO is, or maybe a board member or two, that chooses to speak out on their own. But it's a different thing when you're talking about the formal SEC proposal shareholder process. And it doesn't seem like that is the right vehicle for, and I know people use these terms, for politicized ideological agendas to be formalized through the proxy process.
So Brian Shore is next.
Rob, you touched on another constituency here the panel is essentially focused mainly on the issuer's perspective and the proponent's perspective. The third perspective would be the rest of the shareholder base. And how do we think they react to the number of shareholder proposals that are out today? Do they think there are too many? Do they think there are too few? And do we think that they believe that the process does allow for that dialogue, that corporate democracy to actually work by having shareholder proposals? And what we're saying here is that maybe there are too many, and the question is, do other shareholders agree with that statement, if that's really if that's the position that would be starting from, that there are too many proposals?
So I would just be a little, I would add a friendly footnote to that, which is to say, to go back to a point Colleen made earlier, which is to say it depends on the proposal and who it's coming from. So, and I think a tendency in this area is to treat all shareholder proposals alike, but it just isn't not like that. The data doesn't read that way. If you look at the way the market responds to shareholder proposals, it depends on who's making it, what it's about, what the shareholder base is, the moment in the, it's very hard to generalize. So I want to try and resist that and just say, the best way I know how to measure what shareholders think is to look at how markets react. And the papers in this area, as Colleen pointed out, that look at how markets react when shareholder proposals are adopted or are not, they tend to respond with particular kinds of proponents, like what are called gadflies, the folks who bring a lot of them. They tend to respond positively when those shareholder proposals don't succeed. And they respond differently to non-gadfly proposals. And in fact, when I dissented from the last administration's change on this, I ran those data and showed that maybe what we should be doing is focusing on the identity of the proponent, as Trevor was hinting earlier. Now that's got its own complications, and there's a reason we didn't do it that way when I was in office. But what I would say to you, Brian, is it depends on the proposal. I think if you talk to major institutions, they will tell you there's a lot of proposals. Now then again, they got their own incentives. Right? It's expensive to read this stuff and pay lawyers. So I don't know what to make of that, but what I can tell you is what the literature says, and that's as Colleen described it earlier.
Next one, Nikhil.
Yeah, so first a comment, which is just when companies say that,
I'm sorry, I was disrupting. I was just curious if Lacera had an opinion on this.
I am here representing myself and not Lacera. But you can look at our corporate governance policies, and it has all that in there. I do know that I think for our version of, I believe it was like 1% to 3% of all the things that we looked at from a corporate governance perspective was shareholder proposals versus comp and other things. But interesting, yeah. And we have a staff to cover it, so it was a little different.
So I think two comments. Well, one comment and a question. I think from the comment standpoint, to hear the notion that shareholders should not take into account political issues when voting when it comes to corporations seems strange when we see corporations taking tons of political positions anyways. And I think shareholders should be evaluating that when they're thinking about the direction of the company. That's just as a point of information. But the question I'm more interested in is that, coming from, for example, my own background previously was as union counsel, right? So unions typically are seen in these discussions as gadflies, just being honest. And what I find fascinating, though, is where can we draw a line? Because, for example, union pension funds are ERISA governed. They have to make decisions in the best interest of the workers that they represent, right? And so I would make a distinction between the gadflies who are gadflying that don't have fiduciary duties, right, or other compensations versus those that do, how uncomfortable that is. And I'd like to hear the reaction of whether that kind of line could be a line that the SEC could take in distinguishing in terms of dealing with proposals, especially when companies don't want to deal with union pension funds in the first place.
So I will note the Carpenters Union submitted 38 proposals thus far in 2024, making them the fifth most frequent proposer.
Yeah, I've never heard unions being referred to as gadflies. I think that at least my understanding when people talk about gadflies, they're some of the same individuals that you're probably all familiar with that submit proposal after proposal. But I think companies take unions and other proponents very seriously. And on your point about, yes, I think companies are being asked to, by all their stakeholders, whether it's employees, shareholders, communities where they live and work, to take stances or sometimes to speak out on various political or social issues. They don't always, or they don't necessarily do that. And there's, as you can imagine, a ton of debate and discussion, and it might depend totally on the type of company. Is it a B2B company? Is it more consumer-facing? What sort of products do they sell, right? Who are their constituencies? And so I don't think it's necessarily the case that companies choose to take political stances as opposed to maybe being asked to by various stakeholders at different times. Like, companies want to focus on their businesses. They want to do what's right for their shareholders, and they want to be successful in their business.
So, can I make a very quick clarification, just on the political point? What I meant, I hear you what you're talking about in terms of social issues. I think I wanted to get a little more granular, and what I meant is, for example, if there's regulatory initiatives at different agencies or legislation in Congress, right? By way of example, that's more what I meant, not necessarily just social. Just things that the company would say, we're going to lobby on this because this impacts the company.
Yeah, so first of all, I want to be clear about something. When I used a term earlier, gadfly, and that has a meaning in the literature I was mentioning, and it means very small individual holders, never a large institution such as a union holder. What I mean, the reason I want to point that out is that I've never, like Marie, I've never heard of someone talk about a union holder that way, and I certainly wouldn't. And the evidence is not about them, it's about smaller holders. And by the way, that makes some economic sense, because a smaller holder internalizes fewer of the costs that Marie's talking about than, for example, a significant holder like the institutional pension fund, the one you're describing. About your point about politics, yeah, I have to say, I'm not sure all of us on the panel see it the same way. I see it a little closer to the way I think you might see it, Alan, which is I understand why companies keep saying that they want to stay out of politics, and my advice to them is maybe you should stay out of politics because they're not. And in fact, I was the author of a petition for rulemaking here at the SEC suggesting that all public companies should have to disclose the way they spend shareholder money on politics for just this reason. While I agree that if you ask most management teams, they would say, boy, we just want to run our business, I then see PAC and other kinds of spending through intermediaries that seems to me like something other than running a business. So if you're asking that question from that perspective, I want to note my agreement. And I want to be clear, I think shareholder proposals are extremely valuable, and I think that because the literature says it. What I think is that they're not one blob we can talk about all at once. We have to be more precise about which kind of proposals are valuable, which kind of proposals are less so, and then help investors and companies know the difference.
Cambria.
Thank you. So I suppose I have a couple of comments about this as someone who comes from corporate governance for large asset owners and has run proxy voting programs and filed shareholder proposals. I think I'm very concerned about, there are two pieces here. There's the process piece, and I do think the process is very efficient from a shareholder perspective. Yes, more shareholder proposals means you're voting on more shareholder proposals, but most votes are instructed in some way at large institutional owners. So, I might have to vote on 20 directors. I don't know. That might be too many. I think also some of the issues that have been raised in the past through shareholder proposals that might have been viewed as kind of out there at the time or might not have gotten majority votes at the time eventually became standards for corporate governance. Majority voting is one. It used to be that, a director got one vote, guess what? They're back on the board. Well, I'm voting for my representatives. I actually want to have a real vote, and it should be a majority vote. Things like supermajority voting, for example, that's a proposal that, for those of us kind of who've been around for a while, it tends to be filed by a quote-unquote gadfly, but still gets, well over majority votes because shareholders want that right. And the whole point of voting is that you register your perspectives one way or the other. And the shareholder proposal itself is a tool to raise issues with your fellow shareholders. If shareholders don't like it, they get bad votes. And I'm just very concerned about the idea of, we're talking about something that's very normative. How do you know which shareholder proposals are good or not? What is a political shareholder proposal? How many are too many? I think I'm with George in, I think being overly restrictive actually could restrict shareholders' rights. When they buy a share, they get a vote and they also get a say. So how do you manage that process? I think also, Rob, you made a point about incentivizing more shareholder company dialogue. And I think for most shareholders, like most large institutional investors, that's baked into the process. In my experience, we viewed filing a shareholder proposal as a failure of dialogue because we would have taken a bunch of steps beforehand to kind of try to reach an agreement on an issue. And a shareholder proposal means we didn't. Marie, the best boards talk to their shareholders and they're engaged. We often filed shareholder proposals at companies that were anything but. But we still own them because we own the market. So I'm still stuck with this company where, the director doesn't want to talk to anybody. And, they're doing things that we view as just value killing. And should we still be able to say that? So I think there are a lot of nuances here. But I also think about experience voting in non-U.S. markets and how the SEC process in and of itself, it's a much more efficient process than going to court. And the fact that ExxonMobil just skipped over everything else and went to court, as a shareholder, that's our money. So they sued us. They spent all this money suing us, to your point, Rob. Whereas, worst case scenario from what we hear from companies, it's 120,000, 150,000. I think it's probably a lot less than that because it's usually internal counsel doing this. My concern, I guess maybe it's more of a comment than anything else, but when we're having kind of these kinds of normative discussions in the context of a governance change, it makes me very nervous. And I don't think the shareholders themselves are necessarily asking for major change here. I mean, that's kind of just a few thoughts. And actually that question, the normative one, is a real one. How do you know which shareholder proposals are good or not? How do you know? Beforehand. That's the thing. The vote is after the fact. How would you determine I don't agree with this topic, so it should be off of ballot. 14A8 actually sets standards for that. If a proposal doesn't meet the submission threshold, it gets kicked out within 14 days. It's not 3 months. So that is a real question, though. How do you know which proposals are good or not? What makes you a good proponent versus a bad one? I know that there's the idea of gadflies, but they've always existed. When I started in the early 2000s, there was a very colorful lady who used to file shareholder proposals, and half of them were in all caps. It was like she was yelling at you. And that's kind of been a thing for a long period of time. And I think, actually, I'll just say the last thing. I think the issue here is that a lot of the proposals that are being filed are uncomfortable for a lot of companies. But the Exxon situation, I think is a bridge entirely too far. It was just ridiculous. No.
Well, we certainly agree about that. About it's funny. You're asking a really hard question, Gabriel. I don't pretend to know the answer. What makes a good proposal? What makes a bad proposal? The best I could do is look at what the evidence from the market tells us, how the markets react. Now, is that an answer to the normative desirability of anything in life? No. Stock markets and sanity are not the same. But I think it's the best evidentiary guide we have if we accept the premise, which I think you don't, that there is some number that is too many. And if that's the premise I'm starting with. But it's a contestable premise, and I hear what you're saying.
I understand your point. I just think setting like, what is that number? I mean, that's the thing. What is the number? I don't know.
Can I add a thought, or is it? So it's a thought. I come from the real estate private equity side, and now I'm in the blockchain space, and I had to make a product, right, like a tech product. And I started thinking and realizing just how smart the people at Amazon are to keep on having you recommend the next product that you should buy. And they also do a good job by helping you think through what the reviews are for those things. If there was a way, and that's what my thoughts were more about this, if there was a way to show this is what the person is that's presenting, this is what they've done before, these are the things that they've tried to get votes on, these things have failed multiple times, it's been 5 years back-to-back of failures, and you see that all up front, then you could still, there may not be a question about how many there are, but you can still say very quickly, oh, this one again? Maybe not. And then maybe for whatever reason, if something has changed, because there would be a material change from year to year, then there might be a reason to do it this time. So it's a way of surfacing the information and making it much clearer and easier for someone to get and understand, and then be able to make a decision quickly, as opposed to having to spend a bunch of time on it every year as if it's a new thing.
But Trevor, there's nothing preventing a company from doing that now. One of the biggest things that shareholders consistently complain about is that companies will not publish the name of the proponent. So actually, we want to know. We want to know who the proponent is, but they're not required to, and a lot of times they don't. And, as I think George mentioned, we get 500 words. They get as much space as they want. So why can't companies just put that in? I mean, do we have to legislate this? I mean, there are some pieces of behavior that's kind of, negotiating in good faith. Like, can we just say that there are some, good processes and processes that aren't as effective, but do we need to draw rules for everything? I'm in favor of just less of that. I don't know.
So Brian has actually given us permission to go a little bit over. So James, and then Brian Helmer.
Thank you much. I remember well my introduction to this shareholder proposal process, and it was representing Microsoft when they received their first shareholder proposal. And what I found was it was incredibly easy to defend, in part because they have a complex system and you have 13 reasons to knock a proposal out. And so in order to get, for an investor to get a company to really look at a proposal, you have to have some experience or work with someone who has knowledge of the process to get it through. The next thing, in being on the other side and working at CalPERS, I was amazed at how few proposals were written. A company literally has millions of shareholders, and the one time you get to communicate with other shareholders, nobody does it. And so in more than half the companies in the S&P 500, almost half the companies, did not have a single proposal. So it goes to the question that Cambria was asking, well, what is the right number? Well, investors voted on roughly 700 shareholder proposals. Is that really too many, even if you have some outliers? Especially with the history in the shareholder proposal process that I learned 20 years ago in some of the things that were actually discussed. And interestingly enough, that the SEC kicked out. Shareholder proposal against Greyhound regarding segregated busing in interstate travel. The Cracker Barrel proposal, which basically firing employees based on who they loved. The Napalm proposal, in terms of whether or not shareholders were interested in investing in weapons that may have some very destructive effects for non-military purposes. And with regard to the gadflies, or the people they call gadflies, I think it's important to note that they get very high votes on many of their proposals, given what they are in fact focused on, like shareholder rights. Or compensation in which you performance-based compensation. So it still goes. I mean, there is a point when there are too many, and there is a point when it could be, in fact, burdensome. But if the average company is getting one proposal in 7 years, and those who are actually getting substantially more proposals are substantially larger companies, is there really a problem? And that's really a question. Is there really a problem? Is 700 too many?
Well, my comment is so similar to that. I would just reiterate, I oversaw the proxy voting process for a large state pension plan. I agree with everything James just said. I don't see what the problem is. We're public shareholders. We own these companies. We want to make a proposal. It's usually after a failure for management to respond. We want to make other shareholders aware of that failure and of the issue at hand. I don't understand why it's not just the company has really no obligation. Just put it on the proxy. We're done. I mean, just let shareholders vote on what other shareholders think is important. If it's meaningful, it will pass, and it'll be advisory. And if it's not meaningful, it will fail. What is the problem? And maybe that's a rhetorical question in this context, but I agree with everything James just said, and just wanted to add that.
So I can share my thoughts on the problem as I see it. And I think it starts with the Arjuna case. I think most people in this room think that was ludicrous that they would sue a shareholder. If you read the complaint, and I encourage you to do so, I think that the motivation for that was because of the nature of the claim and its lack of nexus to shareholder value. So just as a counterfactual, imagine if they had submitted a majority vote proposal. Would they have sued a shareholder over that? And I think Exxon would have been laughed out, of the room across the board, because that's a governance proposal. It's about protecting shareholder value. It's about getting rid of, maybe these entrenched management. But the fact that because of the staff legal bulletin change, that you could make a proposal that has, that is untethered to shareholder value, I think they saw that as an opportunity to try to make an example of Arjuna, and I think that's a bad outcome. I don't think you want companies suing their shareholders, and when you have a proposal that seems like it's destroying value, it's basically catnip to a company that is thinking like that. And so I think that's the cost.
I can appreciate that, and I could also appreciate a state of the world where we were filled with frivolous shareholder proposals to a level that became untenable. But that's just not where we are, right? So that's part of the issue. That I understand the legal problem that lawsuit represented, but there is no real practical issue at least at scale at this point. And I understand trying to head that off, but I also understand that, when you go through my experience for 35 years, constantly battling with company managers that we hire and companies that we own and never getting the information that we want, or it's a battle with people that work for us, and it's a frustrating battle to continually be going through. And to me, this represents another version of that battle that's equally frustrating at times. So
it makes good sense. And just offer one last thought. I think I'm very interested in giving you more tools in that battle. What I'd be concerned about would be something like what Bobby has just mentioned, which is that this ends up in a policymaking escapade for the federal courts. As Bob Stebbins mentioned, first of all, the judge in the Arjuna case, if you read that opinion, and I encourage you to read it, it's very clear to me that judge had a view about the cost of shareholder proposals. With respect, I say that the judge's view wasn't especially considered. It just copied and pasted the Business Roundtable's brief into the federal supplement. But that's the risk you run when you leave this up to a non-expert. And that's why I would suggest humbly to this body, if you're not convinced there's a problem, then say there's no problem. But if you think that heading off what Professor Bartlett has just described is worthwhile, it might be worth a conversation about what tools make sense. For example, making them, Brian, answer your email, making them come to your table, making them do that if they want help from the federal government in later excluding a proposal. That's just to throw out a thought.
And just to add one thing, maybe I'm the only one representing issuers or corporations, is I don't think that most companies refuse or decline to speak with their shareholders. I mean, there are a lot of good companies that do have discussions, negotiations. So I think it's important to note that.
All right. So I did promise George very quickly if you just want to take 10 seconds and say your piece. And
Yes.
then I think we'll wrap up. Thank you guys all so much for the panel.
Yeah. So I just wanted to clarify because I started this discussion by provocatively saying, well, there's no such thing. Well, I didn't really quite say that there's no such thing as too many, but maybe the implication was that there is no such thing as too many. And I think, of course, there is such a thing as too many. But are we at that point? I don't think so. And if would you rather have more or less? Would you rather have a little bit too many versus a little bit being too restrictive? Then I'd err on the side of having just a little bit more than less.
Thank you very much, everybody.
Thank you. That concludes our question and answers. I'd like to thank Colleen and the Owner Subcommittee, which is the sponsor of this panel. I'd like to thank all of the panelists and the participants for a very informative and helpful discussion. Thank you so much for joining us this afternoon.
Thank you.
Our next set of business are subcommittee and working group reports. We'll receive brief reports from our subcommittees and working groups. First, Colleen, investor as owner.
Sure. So Gina Gale is actually the chair of Investor as Owner. However, she's not here today, so she had asked me to fill in. So for Investor as Owner, as of right now, we honestly don't have a lot. We have had some discussions about potentially participating in the disclosure panel and what that would mean. And I guess that is an option that we may have coming up in December or thereafter. In terms of recommendations, we obviously have not met to discuss our panels today, but hopefully we will, have a fruitful discussion and perhaps we can get a recommendation out of what we heard at our panels today.
Colleen, thank you. Andrew, on behalf of Market Structure.
Yeah, thanks, Brian. So the market structure subcommittee since the June meeting met 3 times on June 20th, July 18th, and August 15th. So a lot of the discussion was focused on some of the previous panels that we had and the recommendations that we would like to see. Going forward. And so the first was following the March 2024 panel on equity market structure, discussing the issues that surfaced from that related to tick sizes, access fees, and then around the auction system and best execution. And so obviously since then, yesterday we saw the commission come out with a rule that addresses a number of that. And so in the next upcoming meeting, which will be this Thursday, so for the new members who have joined, feel free to join at 2:30 p.m. Eastern. We will be discussing if there's any other pieces of that we would like to continue to look into, and then also talk about issues that are also related in the options market, and then also in penny stocks as well. So that is on the equity market structure pieces. We are also working on a recommendation that is close to being completed related to the June 2023 meeting, talking about the SEC as regulator of private funds and exempted reporting advisors about outbound investments in countries of concern. And so we have discussed potential recommendations related to more transparency into these types of investments and the purposes of them through Form ADV, as well as transparency and any kind of legislation that might be necessary around the investments through a Form PF reporting. And so these are discussions that are continuing to be ongoing. And so we will also be having discussions thinking about the rise of private credit. And so that is something that is on the agenda to discuss for a potential future panel as well.
Thank you, Andrew. James, Purchaser Subcommittee.
Thank you much, Brian. Well, within Purchaser, we're saying bye to many members. That includes Paul Somerset, Nancy Lamont, Jamila Abston Mayfield, Alice Steinball, and Leslie Van Buskirk. Given that purchaser has one member, and he has elected me chair. So we look forward to the new members joining purchaser for a very exciting season where we'll be investor focused, market efficiency, and things that fit within the regulatory framework. And we're already beginning discussions on what we can present early on. Thank you much.
Thank you, James. Christine?
The Disclosure Subcommittee met several times since the last meeting. In August, we received an update from the Investor Advocate on the OIAD Objectives Report for 2025. We are currently working on a recommendation following the June 2024 panel that examined the role of intermediaries or investment advice givers who are providing investment advice primarily through social media, also known as finfluencers. And so we hope to have a recommendation to address some of the gaps with respect to oversight and regulation of advice coming through those channels for the December meeting. And as Colleen alluded to, we hope to have a panel at the December meeting that will address certain disclosure issues.
Thank you, Christine. Paul Roy, Access and Inclusion Working Group.
Yeah, thank you, Brian. The role of the working group is to focus on and hopefully make sure that the IAC factors in access and inclusion and diverse perspectives into the work of the IAC, particularly with regard to panelists, focus topics, and recommendations. We've met 3 times since our June meeting. At each meeting, we discussed potential topics to be considered by the IAC, including effectiveness of disclosure, investor access to private investments, and potential changes to the accredited investor definition. We also discussed the Investor Advocate's report on objectives for the fiscal year 2025. We discussed access and inclusion implications regarding, as Christine mentioned, the potential recommendation regarding the regulatory framework applicable to finfluencers. We also noted that the SEC recently kicked off its biannual collection of diversity self-assessment submissions from regulated entities. These entities have until September 30th to make these submissions unless they request an extension. The SEC uses this data from the submissions to assess and report on progress and trends in regulated entities' diversity-related activities. So that summarizes the activities of the Access and Inclusion Working Group, and that concludes my report, Mr. Chairman.
Thank you, Paul. And that concludes our subcommittee working group reports and brings us to the end of this meeting. I'd like to thank, as always, Christina, Mark, Danielle, Tony, and the full supporting team of the SEC staff for keeping the IAC running smoothly, and until our next meeting in December. Thank you.
Thank you.
Thank you, Matt.
Thank you.